Patricia Van Haren, family law attorney. The 5 things you must know about student loans and education debt when you're divorcing. Number 1, in California, your spouse is not obligated to pay the student loans in the name of another spouse. Any loan that's incurred during the marriage for education or training of one of the parties is not included in the community division of assets and debts. It must instead be assigned to the spouse who received the benefit of that education. Number 2, on the dissolution of a marriage or a legal separation, the community may even be reimbursed for the contribution to the other spouse's education, so long as it enhances the earning capacity of that spouse. So if there were significant payments made on the education or towards student loans, then the other spouse may be able to seek reimbursement for those payments made. Number 3, the reimbursement of a loan for education may be reduced or modified if any of the following exists. So the community has substantially benefited from the education. So they'll look at whether the degree allowed the person to contribute more to the community than they paid for that education. Or when both spouses have student loans, each spouse will pay their other loan and there will be no offset against the community. Or C, the education or training enables that party to engage in gainful employment that would substantially reduce any spousal support that would have been paid. Number 4, the benefit to the communities of a spouse's increased earnings that's due to the education or training is going to depend on whether the marriage was long-term or short-term. So the community is presumed to have a benefit if we have a long-term marriage, a marriage that lasts over 10 years. In that case, the spouse would not be entitled to any reimbursement, but if there is a balance on the loan, the spouse who received the education will also receive that loan. Number 5, know when your loans were taken out. Also, document if the loan went to pay for community expenses, such as housing, food, or utilities. If that's the case, then you may be able to receive a portion of your loan paid that went towards the community property expenses. While you may not be able to have your loan repaid by your spouse, you'll also not need to repay their loan. So use those loans to negotiate in your divorce process. We once had a client who had a substantial amount of student debt, and their spouse wanted the loan to be divided and reimbursed in the property division. So the parties had only been married for 5 years, and our client supported the spouse while they were in school. There were no contributions to the household by the spouse, and we were able to get our spousal support, which would have been paid, reduced and actually waived, because we agreed that the community would not seek reimbursements on that loan. If you have questions about student loans or your spouse's student loans, shoot us over an email or give us a call.